So if the law today were technology neutral, what would that look like in practice for peer-to-peer securities transactions via smart contracts? That's what we're going to discuss today on the Law of Code podcast. And joining me is V. Lee. She served as general counsel of Anchorage Digital, was partner and head of regulatory and policy at Bain Capital Crypto, and was the deputy GC and compliance officer at Worldcoin. She also spent almost 6 years at the SEC as senior counsel in the Division of Enforcement and chief counsel of the Legislative and Intergovernmental Affairs Office. We're going to talk a lot about her article titled Peer-to-Peer Transactions, a Technology-Neutral Framework for Securities Regulation in the Digital Age, as well as an article she co-authored on market structure, diving into what is market structure, what does it encompass, how did we get to the existing market structure setup that we have in the US, and where we can improve with crypto. V, thanks so much for joining me. Welcome to the podcast.
Hi, Jacob. I'm so excited for the return of your podcast. I love forums where I get to totally nerd out on the law as much as I can. And it doesn't get any nerdier than the law of code. And I mean that as a huge compliment. So thanks for having me.
This episode of the Law of Code podcast is brought to you by Day One Law, a boutique corporate law firm founded by recurring guest and friend of the show, Nick Pullman. Nick and his team at Day One Law provide strategic legal counsel to startups, crypto projects, and Web3 innovators. You can get in contact with them via the top link in the show notes below. You start the article is with a particular scenario, and that is if you hand me a paper stock certificate and I hand you cash. Under US federal securities laws, this intermediary-less transaction is entirely lawful. We can do this without having to register with the SEC, report, or be surveilled. Why is it different if we conduct transactions digitally?
Right. So a lot of people don't realize this because, almost all securities trading these days happens through regulated intermediaries like brokers. But actually, there's nothing in the federal securities laws that says if you want to purchase a security, you can only do it through a broker or some other regulated intermediary, right? It's perfectly legal for me to say, hand you a paper stock certificate and you hand me a wad of cash. That's just a peer-to-peer transaction in the analog world, and it's totally legal. So then the question becomes, should that same peer-to-peer transaction between two private parties suddenly become regulated just because we now have the technology to do it digitally without an intermediary, right? So I send you a tokenized version of that same stock via a smart contract on a decentralized blockchain network. No third parties, no broker, no clearinghouse, literally just automated software facilitating that trade. So functionally, nothing has changed, right? It's still a peer-to-peer transaction. But from a regulatory perspective, does that change everything? And should it, if the securities laws are supposed to be technology neutral? So that's sort of the premise of my article. And I think, this concept is actually really important because it raises a bigger question, and I think a really profound question. And that is, look, technology is going to continue developing and probably continue to enable the government to surveil and have its eyes and hands on more and more of our private transactions, our communications. But just because new technology enables the government to regulate something doesn't mean that they retain the same justification or legal authority to do so. Right? So another way to think of it is if the same economic activity is permissible in the physical world, then the use of new technology to facilitate that same activity should not by itself suddenly trigger additional regulatory burdens. And this concept isn't just about securities law, right? Courts have been struggling for years over the scope of something called the third party doctrine, which says that you lose your expectation of privacy when information is voluntarily shared with third parties like banks or your cell phone provider. And as you can imagine, the scope of this doctrine has really just kind of exploded in the digital age as people's lives increasingly move online, and nearly all online activity involves regulated intermediaries now, right? So as a result, the courts have been really struggling to reconcile this doctrine with modern expectations of privacy and constitutional protections under the Fourth Amendment. It's, this idea is playing out in a lot of different legal spheres. And so, decentralized systems are sort of potentially an antidote to that. But again, a similar tension is playing out with DeFi, right? DeFi really does challenge this paradigm that financial activity between private parties at scale has to always be routed through a gatekeeper. That's not true anymore with this technology.
And I think the paper that you wrote on market structure does an excellent job explaining why this is the case, why we have these intermediaries and how they've grown over time. And we will talk about that in a minute. But one of the things I wanted to play devil's advocate a little bit and talk about, because we can both agree that there are differences in the analogy of handing someone a stock certificate compared to using DeFi rails to make a similar transactions. But, and as you write in your article, not all DeFi activity is beyond the reach of securities law. And I think that's something that there is a bit of a tension around, where on one hand, you have people in the crypto space saying that it should sit squarely outside securities laws. And then there are others who are saying it should sit outside in parts, but there are other parts that do fit in. So I'd love to hear you expand a bit on where you see the intermingling between securities laws and digital assets.
Sure. So let's start with the actual laws, right? The SEC would argue that at some point, even peer-to-peer transactions at scale can begin to look like regulated financial intermediaries under the federal securities laws. So for example, if you are seen to be facilitating securities transactions, that could make you an exchange under Section 3A1 of the Securities Exchange Act. And then the SEC under former chair Gary Gensler tried to expand this to communication protocols. Or if you're engaging in the business of effectuating securities transactions for others, this could make you a broker under Section A of the Exchange Act. Right? So the question is, are DeFi protocols doing these things? So first of all, we have to recognize that there's a spectrum, right? DeFi protocols can range from automated market makers to peer matching protocols to smart contract based escrow and atomic swaps, which all function a little bit differently. But I think the guiding principles should be things like, does the protocol have control or governance or discretion over the trades that are happening on the platform? So, code that merely enables communication or execution is really different than some sort of centralized intermediary that has control or discretion over assets or funds, right? So in this sense, a truly decentralized protocol is really no different than, say, a Bloomberg messaging app, or even like a spreadsheet that just helps over-the-counter desks manage order flows. So there really is a difference between infrastructure that aggregates liquidity and makes markets like NASDAQ, and on the other hand, autonomous software that lets users transact peer-to-peer. And then I would say the final point is, scale and automation alone should not be enough to trigger regulation. Like, I think you really do need to look at these other factors. And that's not to say that I don't get the impulse to regulate here, right? If it was only a few people using DeFi, no one would care. But I do think part of the fear here is that DeFi has the potential to replace key components of the existing financial system without centralized intermediaries to register, examine, or sue, right? And I can see why that scares regulators.
And it also scares the incumbents as well. We've seen such a huge pushback from the banking system when it comes to yield-bearing stablecoins, for example, right? Where now we're getting stable bills and Genius Act and all these bills that are coming out where you get the access to stablecoins. You take on the risk of buying the stablecoin, but you don't get the benefit of any yield that those stablecoin issuers may be getting because they're forbid from actually paying that out.
Yeah, I really liked your episode with Larry on this. But yeah, it's the same sort of dynamic.
And I think it's pretty natural that we've seen that in many areas that DeFi touches. There's also this area of DeFi that is outside securities laws, and we've hinted at it, and I've spoken to previous guests about this, which is, how do you regulate DeFi then? If we are going to have this system that exists, it doesn't exist in a vacuum, and regulators will want to have some guardrails up. I think your article did a great job of taking a principles-based approach rather than a functional approach, where you're saying what makes sense, what risks are we trying to protect users?
Yeah, so I think this is a very American thing, right? This idea that if we want something to be secure or orderly or fair, it has to be regulated by the government. Part of that is probably we have a relatively well-functioning government in the US, especially when it comes to financial products and services. Our regulators are some of the best in the world, right? So, but all that said, that doesn't mean that industry-led initiatives like codes of conduct, compliance frameworks, and other kind of self-regulatory or self-certification regimes can't be effective to ensure that we have security and transparency and consumer protection. Did you take property law in law school?
I did.
Jacob? Yeah. So did you guys ever read this? I forget exactly what the book is called, but it's about lobster fishermen in Maine.
Depends on it's not coming to mind.
Yeah, so it's for some reason it's a book that I think about a lot because it's really interesting. So what it's about is we were assigned this book and it's about lobster fishermen in Maine and how they've developed their own informal rules to basically police the waters that they fish in. And the idea behind it is you can actually have a very effective system that's not based on formal laws, but that's just based on like social norms and industry customs that people enforce because it's in their best interest as a collective group to do so. And so I really love this idea, right? Because it can be effective. And the idea is that, first of all, I think market enforcing mechanisms are very powerful, right? So like if every time I use your DEX, I get defrauded, like that DEX is not going to exist in a year. Or, if I'm on a centralized exchange and it's getting hacked every other week, same idea, right? So first of all, I think market dynamics have a very powerful forcing function, but I think industry norms and standards can also be really effective in making sure that we are achieving the same policy goals that laws can achieve, right? So just to give an example, there's this organization, I don't know if you've heard of it, it's called INAPA, or the International Association for Trusted Blockchain Applications. And there's so many organizations out there and industry groups that are doing like similar kinds of really good work. But they just put out a report. I was looking at it. They put out a report this past February, and the report calls for things like real-time financial reporting of things like liquidity, collateral, and other kinds of risk exposure with DeFi protocols, calling for smart contract security standards and audits, imposing sanctions and AML compliance at centralized on and off ramps. And they make a host of other recommendations that I think are really interesting. So I would really love to see the industry band together more, whether it's through these kinds of groups or trade associations to think about what are some best practices and industry norms that we want to abide by. And I think that can be just as effective.
And I think if any industry member can speak about that, it is the legal profession where you have this regime that lawyers are part of. In Canada, there's one in the US. I know there are in most places, this law societies, right? And the ABA and different bar associations where now you have this self-governing feature. And I think something like that in the future could develop when it comes to DeFi development, licensing, etc. It's a self-policing framework that you need to abide by the rules in order to be a part of. And maybe that looks different, and it definitely would look different when it comes to publishing code on chain that is used in DeFi. But I do think it's proof that the model works.
Yeah. Exactly.
And so when it comes to the structure of the market, the one thing that I really enjoyed about your article was learning the history of how everything came to be. And really, you did a great job of distilling it in a sense of here's where we were in the 60s, here's why we began to change, and then here's how it got so bloated and intermediary heavy to the point now where we're seeing the third-party doctrine expand, and we're seeing everything that's come along with that in terms of the loss of privacies. And it reminded me a lot about what I've seen in Canada when it comes to Quadriga. After Quadriga collapsed, we saw our securities regulators step up and say, wait a minute, if we're going to have these crypto asset platforms here offering services to Canadians, there needs to be certain benchmarks that they hit, whether it's not intermixing company funds with consumer funds. And you allude to that happening in the 60s when it comes to securities from the business that the business owned versus their clients owned. I'd love if you could just talk, before we dive into that history, what market structure is. And I'm hearing a lot of talk that it's the market structure summer. The US is gearing up to enact some rules around market structure that will impact crypto quite heavily and are sort of tailored for crypto. So when people talk about market structure, what does that mean?
So when I think of market structure, what I'm thinking of is like the whole picture, right? So how is a trade issued? How is it custodied? And how is it traded? And what is the infrastructure and the different processes involved in all of that? And then, of course, how is it regulated? And so obviously there's a structure in place that has been around for decades when it comes to traditional securities. And so now Congress is trying to work on creating market structure for crypto. And it's going to be a beast. So
it definitely will be when you think about all the moving parts there. I'd love if you could give a give that history that you do described in your paper. And I'll link that in the show notes below so people can read it if they'd like to follow along or to read it in detail after. But very interested in hearing you explain the history behind market structure.
Yeah, so, what inspired us to write this article is we realized that traditional market structure is actually really poorly understood. And what I mean by that is this, right? If you ask the average person, and honestly, even someone who works like in the capital markets, if you ask them, what is the life cycle of a securities transaction? What are the different intermediaries involved? And why are there so many of them? Why are each of these intermediaries subject to a host of regulations? And what risk or policy objectives are those regulations meant to address? Why can't I buy a share of Apple stock directly from the New York Stock Exchange? Why do I have to go through a broker? What's the reason behind that rule? Like, a lot of people wouldn't know the answers to these questions, right? And yet how we design crypto market structure regulations, how can we design those if we don't understand traditional market structure regulation and the policy objectives behind them? Because the truth is that a lot of the same risks exist in crypto that exist in traditional securities issuance, custody, and trading, while at the same time, crypto presents some unique risks that the traditional regulations just don't address, right? So I would argue that you can't design an effective crypto market structure law without understanding traditional market structure and the history behind it. And so that's what inspired us to write this.
And then in terms of that history, to go back to the 60s, in the article, you write about how there was a time period where, because the market was so frothy, things continued to go up, these brokers could get away with not actually knowing the location of every security they were selling their clients. Yeah. And of course, when the tide turned and the market began its downward spiral, quite a few went belly up. And I think the number's like 100, over 100 went belly up. So I'd love if you could just take us back to 1960, 1970 and what happened there.
Yeah, so this history is so fascinating to me. So today's securities markets are highly intermediated, right? Everyone knows that. And it's not because it is like the best model that we could come up with, like far from it. It's actually the result of a combination of like historical developments and deliberate policy choices that we made and some political horse trading thrown in there. And one of the key events that led to the system we have today is what's called the paperwork crisis of the late 1960s and early 1970s. So what was that? In the 1960s, the US stock markets were really booming. New York Stock Exchange saw daily trading volumes quadruple between 1960 and 1968. And brokers just couldn't keep up with it. Trades were still at the time manually recorded and settled using like literally paper stock certificates, trade tickets, and ledger books. Like you see this in the old movies. And brokers basically collapsed under the weight of all of that, right? They, like you said, they lost or misplaced stock certificates. Sometimes they had to shut down for weeks just to catch up with a paperwork backlog. And basically the system eventually broke down. So of course, lawmakers and regulators totally freaked out and realized they had to completely overhaul the securities trading infrastructure. And at the time, they explored a bunch of different models and eventually settled on a model that introduced multiple layers of intermediation, much of which we still use today, right? So the DTC was created to hold securities in immobilized form. And all that means is they're holding it in bulk, not in the hands of individual investors. And that allowed trades to be settled electronically via book entries rather than through the exchange of physical certificates. And then they developed the modern clearance and settlement infrastructure that we have today. So the National Securities Clearing Corporation, now part of the DTCC, which was created to net trades and reduce counterparty risk. And then the Securities Act's amendments of 1975 gave SEC authority to create a national market system and centralized clearing, which embedded even more intermediaries into the trading and settlement process. So I think what's really interesting is that this system developed the way it did because we didn't yet have the technology to create a more direct, efficient, and trustless system for trading and owning securities, right? So in fact, if you look back at some of the SEC studies at the time, so we went back and we looked at a lot of the deliberations that went on in both Congress and the SEC about like what is the best model to adopt. If you look back at some of the studies and some of the discussion they had at the time, the system we have now was always meant to be a temporary solution, right? Like no one wanted this. It was actually just seen as a necessary evil until the technology existed to create something better, something more direct, something more trustless, right? And so what's fascinating is that we have that technology now, and it's called crypto and blockchain, right? You can trade peer-to-peer or issuer-to-peer near instantly, transparently, with records that are reliable, without the need for multiple intermediaries, and without things like counterparty risk, right? So it's funny because like critics like to say that crypto has no use cases or that crypto is a solution in search of a problem, but actually it's a solution to a decades old problem. And that's what makes it so innovative.
I thought that line in your article was fantastic, that crypto is a solution to a decades old problem, because you're right. That is what we hear so often. And it's people not realizing that the intermediary approach that we have to securities laws and many other financial products is a solution to a problem that existed that when there was no other solution. But now we actually do, with these different protocols that we can access without an intermediary that are autonomous, they are that solution. The problem now is, how do you go from this highly restricted area where the market structure exists and has been built out and does work to one that has a lot less friction?
Yeah. So, I think when you think about it that way, right, that's why it doesn't make sense to try to shoehorn crypto into the legacy framework, because you're sort of like that sort of has it completely backwards, right? Like crypto has a lot of benefits that obviate the need for all these intermediaries because it eliminates or prevents some of the risks that the intermediaries were trying to solve for in the first place. So that's why, it's helpful to have an understanding of traditional market structure as you're trying to create crypto market structure. But at the same time, crypto does present unique risks, right, that new market structure legislation has to address as well. So our article talks about that a little bit. Crypto market structure, I think the important thing to consider there is we want to preserve the benefits of the technology as much as we can as we're designing this structure, right? So like I mentioned, right, trading crypto assets doesn't require clearing or delayed settlement in the way that traditional securities do. Trading crypto assets doesn't require brokers or third-party custodians necessarily, right? So if you're trading on a centralized crypto exchange, you can trade directly on the platform's order book. So that requiring the use of a broker would just introduce an intermediary that wouldn't otherwise be needed, right? So that would then in turn introduce principal agent risk for consumers and increase custody risk, since customers would now have to trust two third parties with their assets instead of one. And then another example is trading crypto assets doesn't require transfer agents. So, blockchain technology allows transactions to be recorded accurately without the use of third parties. So those are just some examples of the benefits of this technology that we really want to preserve, where we don't want to introduce intermediaries that exist in the traditional securities context, because those risks just don't exist in the blockchain and crypto context.
And given the various roles that you've had, particularly all the time you spent at the Securities and Exchange Commission in the US, you are very attuned to the risks that do come with using crypto rails to transact assets, whether that be crypto asset securities or tokens, meme coins, etc. There are risks that accompany them.
Sure.
Is there one that you see regulators having the most difficult time wrestling with when it comes to just allowing these rails to operate in a way that is more beneficial than the existing system?
There are risks that are unique to crypto that I think a lot of consumers don't understand, right, and might struggle to deal with. And so I think this is something that lawmakers and regulators should take really seriously and address in any crypto market legislation, right? So the first one is kind of a very basic one, which is crypto transactions are irreversible, right? So if I send you like Bitcoin, I'm not getting that Bitcoin back unless you decide to just do a whole new transaction to send it back to me. Like it's what's done is done. So this is, I think, not something that consumers and investors are used to in the traditional securities context, in part because there are intermediaries that can jump in and address that. And then there is that time delay, right, that allows you to make corrections for errors and things like that. So that's kind of just like a basic example, but it is something that is unique to crypto. And then another example is, if you lose your private keys, like you lose your assets. There's no going back, right? And so that's also not something that most people are used to, right? Like most people access their funds through accounts that are held at centralized intermediaries. And if they forget their password, which I personally do all the time, there's a way to recover it, right? It's not like, who's that? There's this guy like in the UK who he had like I shouldn't be laughing because this is like very tragic and sad. He had a hard drive And I think he had, I don't know what it would be worth today, but like literally billions of dollars worth of Bitcoin. And he accidentally threw it away. So it's like probably in some landfill in, I don't know, like I forget the name of the town, Cardiff by the sea or something. And so he's like spent years fighting with the city to get him to allow him to be able to go in there and like look for his hard drive. And I think they actually finally allowed him to. Anyway, that's just like a horror story, right? About like, you know, if you lose your private keys, that's it. Like your crypto's gone forever. And so I think there are some, you know, consumer protection sort of issues that policymakers should take seriously, that are unique to crypto. And then there are just other things that like, you know, the average person maybe isn't aware of, like the average person who is on a centralized crypto exchange trading tokens. But, you know, there are protocol risks, right, that are inherent to some of these tokens, right? So if you own a token and that protocol is hard forked, like what happens to your assets? And do you get ownership of the new assets that are on the forked chain? Right? Like these are questions that don't have clear answers, especially when it comes to something like a centralized crypto platform or like if you're a custodian, or what happens in the event of a 51% attack, right? Like what happens to your ownership of your tokens then? So these are, again, all risks that are very unique to crypto that I think most consumers don't really understand and certainly aren't fully equipped to deal with, but it's something that lawmakers and regulators should be seriously thinking about.
And I think that's where your point about, or your explanation of the history becomes so valuable, because, well, these are novel issues to the crypto industry. They're not always novel issues to the world, right? And when you think about intermediary less trading or the irreversibility of certain transactions, you could argue that the same thing is true when you trade a physical asset for physical cash. I can't just click undo there. I would have to bring you to court and we'd have to go through the legal process. And you can do the same thing with DeFi transactions where a court could order the returning of a certain token, just as you would in traditional markets today.
Yeah, I think that's a really important point, actually, because, you know, where else this comes up a lot is this idea that like, you know, a lot of the fraud and misconduct that happens in the crypto markets, you know, it's possible that we don't need like a dedicated brand new like securities regulatory regime for that, right? A lot of people argue we have things like common law fraud statutes that could provide remedies or recourse to people who are defrauded or who are victims of scams and things like that, right? Like we do have existing tools that probably could address a lot of these like investor protection, consumer protection issues. And so I think we should think about that.
And I think that same principle holds true when it comes to sanctions, for example, when we saw Treasury sort of go beyond their scope, sanctioning smart contracts. And the court said, you can't do this. You can sanction people or property, but you can't sanction a smart contract, which they found to be neither. And it's such a good example, right, of saying, okay, sometimes the principles fit. If not, there is a solution somewhere here. We just don't go after the intermediary as we're so used to doing. And I think that's something that will be interesting to see, particularly when it comes to this market structure legislation that we're expecting to see.
Yeah.
I mean, where do you sit in terms of how market structure bills have looked in the past? As someone on my end, I haven't gone through them in depth to have a great understanding of where they've sat, whether it's been great or bad. I know a lot of people have raised certain issues that have come up in almost every one of them, often around decentralization or certain aspects of that. Where do you sit on that? What would be sort of your 10,000 foot perspective?
Yeah, I mean, I think one of the things that I struggled with the most with the first versions of legislation like Fit 21 is that it created kind of like bifurcated and fragmented markets that I think would have proved really difficult to enforce and very unworkable in practice. And so I think, you know, the staff and the drafters took those concerns really seriously. So I think the next version that we see is going to be, you know, it's not going to revolve so much around questions of, you know, how is a digital asset acquired? Is it affiliated with the issuer, right? The things that ended up, I think, inadvertently creating sort of a complicated bifurcated market. I think it's going to start more from first principles, right? Sort of the framework for my article. Like, what are first principles? What are the risks that we're trying to address? right? It could be something like information asymmetries between the issuer and the purchasers, or the need to prevent market manipulation, right? Things like that. So starting from first principles and then designing a structure around that instead of focusing so much on the nature of the asset itself and how it was acquired and that sort of thing.
And when you follow that to its, what some could argue is its logical conclusion, I could see a world where we start to see intermediaries prop up between DeFi and the consumers. When, like, you use the forgot password example. I mean, some could argue that man's best friend is a dog. Some could also argue forgot password button is man's second best friend, because it's just, it's so helpful for people, and even the ability to undo transactions, stop an email before it's actually sent. That is a very valuable thing that we have that exists. Do you see a world in the future where there are these intermediaries that sort of, I don't want to say are a toll, but they block, like they are that first point of contact, almost as if replacing the existing front ends for DeFi protocols, or those DeFi front end protocols themselves become those intermediaries that have to follow certain rules before things go on chain?
Yeah. So for me, when thinking about this, I think it's actually going to be really important for us to push back against that impulse, because I can see why it would be tempting to try to protect consumers as much as we can. But I think what's important here is we want to preserve that optionality, right? So like, if you don't trust yourself to manage your own private keys and you don't trust yourself to self-custody, then go to a centralized exchange. Like, you should have that option, and that option should offer you the kinds of protections that you're looking for, right? But there are people who really do value the privacy and self-sovereignty of being able to self-custody and being able to go through a DEX, and they trust themselves to do things like manage their own private keys and seed phrases and things like that. That should remain an option for them. So I think it really is important to make sure that consumers and investors are educated, right, about how these things work and what the risks are. But I think it's really important to preserve the full sort of menu of options depending on what consumers are looking for.
Yeah, that's a really good point, and I'm glad you raised that, because I think it's so easy to think of a one-size-fits-all approach when that might do more harm than good, particularly when it comes to something like crypto, where you do have this ability to have a front-end regulated system like a centralized exchange, and then you do have the ability to allow people to self-custody if they choose to. No one forces anyone to go either way, and I think choice and freedom has always been fundamental to the US approach, and I hope that will continue here. And is that something you predict we see with the upcoming market structure bills?
I think so. And I don't know if all of that is going to be captured in that legislation, right? I think it's very possible that DeFi could be saved for another day, just because it is a very complex issue that I think Congress and the regulators need more time to study. It's very possible that something like that could be excluded from the market structure legislation and taken up at some later point. Or, it could be that Congress, the SEC, and or the CFTC, with providing further recommendations and conducting studies on this. So I would like to see that. I think that is the best approach.
And last question for you about the broader crypto law topic. You spent quite a few years at the SEC, and you've worked there in different divisions as well, I believe. So were you surprised to see such a quick changing when it came to the willingness of the agency to work with crypto? Because as an outsider, I wasn't surprised by it, but I did find it illustrative of the influence that politics has on what should be a nonpartisan agency.
Yeah, so it's funny that you mentioned that, because I published an op-ed this week because I sort of was disturbed by the same thing, right? This idea that like a change in political leadership could result in such a drastic change in approach by an agency. And so what I called for in the op-ed was, we actually need to make fostering innovation like a formal part of the SEC's mission, for that very reason, so that an agency can't swing so wildly between being completely hostile to innovation to being pro-innovation like overnight. Like, that's not good for the market. It's not good for consumers, and it's not good for innovation, right? So that's one of the things I called for, is actually like literally amending the federal securities laws to, alongside capital formation, investor protection, and market integrity, make the promotion and adoption of innovation and making sure that the SEC modernizes and stays modern, to make that an explicit part of their mission and their mandate.
And in terms of what we see next from the agency, is there anything in particular that you're keeping an eye out for or are anticipating the agency publishes with regards to crypto?
The crypto task force at the SEC has been hard at work. They've been moving forward really aggressively. I think setting the groundwork I guess Chair Atkins has officially started, right? So setting the groundwork for him. But I think there's also been a ton of dialogue between the SEC and members and staff in Congress that are working on things like market structure legislation to make sure that they're on the same page. And so, legislation, like when we eventually pass market structure legislation, it's going to be historic and super amazing and cool. But in a lot of ways, it's really just the start, right? Like it's then going to be up to the SEC, the CFTC, maybe other agencies to actually implement that legislation. And that's really where the rubber meets the road and the details are going to matter. And so what it seems to me that the SEC is doing now is they're kind of getting a head start on the stuff they know Congress is going to ask them to do anyway, right? Once the legislation passes, right? So thinking about things like, if a token issuer wants to register, what's the information that they have to provide in the disclosure form? Thinking about what are securities versus commodities? What does the SEC have jurisdiction over? So really, I just see a lot of the work that the SEC is doing is really just getting a head start on what they think Congress is going to ask them to do eventually anyway.
Yeah, that's a very good insight because I think for a lot of people, they're seeing this as the first steps and that aligns with your thinking. And I think that's good to hear. I'd love to just quickly hear your Genesis block. It's a question that I've asked all my guests about their introduction to crypto and we, saved the best for last, but I just want to hear how you got introduced to crypto, when, where, etc.
Okay, so I was sitting in my office at the SEC. So this was I think my second year as an attorney in the enforcement division there. My supervisor walks in and she's like, do you want to work on this new case? It involves cryptocurrency. It's this group of people who are trying to offer this crypto coin and they're raising literally hundreds of millions of dollars. We have no idea what it's about and what they're telling investors. Do you want to work on this? And so my first question was, what's cryptocurrency? I had heard of, it was 2017. So I had heard of Bitcoin, but really I knew nothing about the industry. I knew nothing about the underlying technology or any of that, but it sounded kind of cool. In some ways, it didn't sound all that different than other cases I had worked on involving penny stock offerings and penny stock fraud and that sort of thing. But I thought it sounded interesting. And so I said yes. And that was kind of the beginning of my journey. And so many books and YouTube videos later, I started to get a better sense of how blockchain worked, what people were doing with the technology, and then just, worked on a bunch of ICOs. And I was in the enforcement division for most of my time at the SEC, but towards the end, I got a really cool opportunity to be chief counsel at the legislative affairs office there. And so I got to work on a lot of policy too, which was a lot of fun, including, a lot of things came across our desk that year, but some of it was some of the earliest draft crypto legislation that Congress introduced. And so I got to work on that and was sort of just hooked after that and decided I wanted to join the industry. And so that's what I did after leaving the SEC.
Well, you've had a fascinating career since and looking forward to hearing what's next. All right. Thanks everyone for listening. That's another episode of the Law of Code podcast in the bank. If you're interested in learning more about our sponsor, Day One Law, you can find a link in the show notes below. We'll see you next time.